This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about bankruptcy and why a bankruptcy court dealt with a judgment for falsely causing an arrest where the person who caused the arrest intentionally was not dischargeable in bankruptcy, and he's going to have to pay the judgment that his victim obtained, because willful and malicious injury by a debtor to another is simply not dischargeable in bankruptcy. In a case entitled In Re Niko T Irizarry, Mark Riley versus Niko T Irizarry, a United States Bankruptcy Court for the Middle District of Florida on September 30, 2025, established that the fraudulent conduct is not dischargeable in bankruptcy. Plaintiff Mark Riley filed a lawsuit against Defendant Niko Irizarry in federal court, alleging claims for civil conspiracy under 42 U.S.C. Section 1983, malicious prosecution, violation of his 14th Amendment rights, common law false imprisonment or arrest, and intentional infliction of emotional distress. Riley's claims are based on allegations with convincing evidence that Irizarry made a false statement that led to the search of Riley's car and his subsequent arrest. On February 11, 2022, the Lee County Sheriff's Office arrested Custodio, Snyder, and Irizarry. Irizarry admitted to the Lee County Sheriff's Office that he lied in a sworn statement to Lieutenant Poklemba of the Lee County Sheriff's Office that he had no prior knowledge that drugs would be found in Riley's car, that he caused Riley harm by arresting him for a crime he did not commit, and that he obstructed the Lee County Sheriff's Office drug investigation by lying in a sworn statement. The court found that Irizarry's false statement in his probable cause affidavit was intentional and deliberate, substantially certain to lead to the search of Riley's car and his subsequent arrest, and wrongful and without just cause. Riley's motion for summary judgment was granted as Irizarry failed to come forward with sufficient evidence to dispute the material fact or the inference created by Riley's evidence. The court concluded that Riley had met his burden of proof, and Irizarry's false statement was both willful and malicious. Under Rule 56A, summary judgment is appropriate where there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. An injury is willful under Section 523A6 if the debtor commits an intentional act with the purpose of causing injury, or which is substantially certain to cause injury. An injury is malicious if it was wrongful and without just cause, or excessive even in the absence of personal hatred, spite, or ill will. Section 523A6 of the Bankruptcy Code provides an exception to discharge for debts, quote, for willful and malicious injury by the debtor to another entity or to the property of another entity, close quote. An injury is malicious under Section 523A6 if it was wrongful and without just cause or excessive even in the absence of personal hatred, spite, or ill will. Here, each of Riley's claims is predicated on, among other allegations that Irizarry falsely stated in his probable cause affidavit that he witnessed Riley with drugs in his hands, that Irizarry's false statement gave rise to a probable cause to search Riley's car, in which the planted drugs were found and for his later arrest, and that as a result of Irizarry's false statement in his probable cause affidavit, Riley was charged with 6 felonies and faced a maximum of 65 years and a mandatory minimum of 25 years in jail. Based on the record evidence Riley presented, it is undisputed that Irizarry intended his false statement in his probable cause affidavit to injure Riley. At the very least, Irizarry's false statement was substantially certain to lead to the search of Riley's car and Riley's subsequent arrest. That is substantially certain to injure Riley. The court found Riley has come forward with sufficient evidence entitling him to a directed verdict that Irizarry's false statement was willful. Once Riley met his burden of coming forward with evidence entitling him to a directed verdict, the burden shifted to Irizarry, and Irizarry failed to meet his burden of coming forward with sufficient evidence to call into question the inference created by Riley's evidence. Based on the record evidence, there was no dispute as to any material fact that Irizarry's false statement in his probable cause affidavit was A, an intentional and deliberate act, B, that at a minimum was substantially certain to lead to the search of Riley's car and his subsequent arrest, and C, wrongful and without just cause, and therefore Plaintiff Mark Riley's motion for summary judgment was granted, and the court entered a separate final judgment determining that Plaintiff Mark Riley's claims against Defendant Niko Irizarry in the district court action are non-dischargeable under 11 U.S.C. Section 523A6. In my opinion, Irizarry's attempt to avoid a judgment brought by Mark Riley for his false arrest and malicious prosecution properly failed. Bankruptcy is a system to help people avoid debts they incurred and start their life anew. It is not available to protect a person from his intentional and willful act to get Riley arrested and jailed. There is no right to discharge the judgment because of the wrongful, willful conduct of Irizarry. At least that's what the court found. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL selma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,200 blog postings. You can also subscribe to these videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. If you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publications for a very small fee. And please tell your friends and colleagues about this blog and the videos and let them subscribe as well. Thank you for your attention.